Hello, everyone. I'm Kate Apostolova, and I'm a senior associate with Freshfields and a member of the YSIAC committee. On behalf of YSIAC, welcome to today's mock hearing by the winners of the YSIAC Writing Competition. So as you probably know, YSIAC organizes an annual writing competition, and this year we asked participants to draft and submit a written brief to a tribunal in a mock arbitration in relation to a procedural application. We received a total of 84 entries from 25 jurisdictions, including Singapore, the US, the UK, Russia, Ethiopia, France, Korea, Romania, Canada, Australia. So a very, very diverse representation from all continents and from all over the world. And the results are out. Our judges, who I will introduce shortly, have chosen the best claimant and the best respondent. So out of the 84 submissions, our judges chose the brief submitted by Alvin Tan as the best claimant and the brief submitted by Lyndon Chu as the best respondent. And we're very, very happy to have them join us today for a mock hearing as they orally deliver their written submissions as counsel before the judges who selected them as winners. So let me just introduce the winners briefly to you. Alvin, can you say hi?
Hi everyone, very happy to be here and I'm very privileged to be part of this webinar.
Thanks Alvin. So Alvin won the best claimant brief. He's an associate in the International Arbitration Group at Schellenberg Whitmer, based in Singapore. He practices international commercial and investment arbitration, and he graduated from the National University of Singapore just last year, I think, and is admitted to the Singapore bar. And Lyndon, the best respondent brief. Hi, Lyndon.
Hi, it's a privilege to be here this evening. Thank you.
Hi. So Lyndon is also from Singapore. He graduated from the Singapore Management University in 2018 and also admitted to the Singapore bar. He's currently an associate in the dispute resolution team at OC Queen Street, a member of the Osborne Clark International Network, and his practice includes a variety of commercial and contractual disputes. So congratulations to you two. Thank you for participating in our mock hearing and role-playing as mock counsel. So we're very excited to have an all-star tribunal as well, comprised of the judges who selected the winners of the YSIAC Writing Competition. So let me introduce them briefly, starting alphabetically with Julie Badard. Hi, Julie. Julie is a member of the SIAC Court of Arbitration and the head of International Litigation and Arbitration Group for the Americas at SCADN. She represents clients in investor state and commercial arbitration and also litigation, and she practices in 4 languages: French, Spanish, English, and Portuguese. And she's described as exceptional and impressive by Chambers and GAR and other directories as well. We also have with us Lang Sun Chan. Hi, Lang Sun, who is the Deputy Chairman of the SIAC Board of Directors and Senior Counsel and Arbitrator with Essex Court Chambers, Duxton. He's qualified in Malaysia, Singapore, and England, and he has a broad practice representing clients in commercial disputes, technical disputes, maritime law, insurance. Before joining Essex Court Chambers, he was the global head of arbitration of an international law firm, and he's described as meticulous and persuasive by those same lawyers' directories. And last but not least, we have my colleague, Jack Tercino, who is counsel with Freshfields, based in our Tokyo office. He has extensive practice in both investor state and commercial arbitration and also litigation in US courts. And prior to joining Freshfield Tokyo office, Jack worked for a leading US firm both in New York and London, where we were also colleagues. So this is our cast of characters for today's show. And before we start the show, or the mock hearing, let me just give you a quick introduction of the mock problem. So the mock case concerned a dispute over a distribution agreement between a claimant and a respondent. The claimant is Huckleberry Corporation, an English company, one of the leading distributors of precious infinity jewels in Asia. And the respondent is Narcissus International, which is a UAE company and one of the largest and most successful companies in the world, which cuts and polishes infinity jewels for usage by customers. So in 2012, the parties entered into a distribution agreement for the distribution of infinity jewels in Asia. But in 2019, the respondent terminated that agreement, allegedly because of poor performance by the claimant. So the claimant initiated YSIAC arbitration against the respondent under the distribution agreement. And the mock hearing today is a procedural hearing, and it will address two procedural issues. One is whether to excuse the attendance at the hearing of a witness unwilling to testify. And a second one is whether to allow for two witnesses to testify via video conference. So the claimant's counsel, Alvin, will be arguing that its witness should be excused from giving testimony at the hearing, and that the respondent's witnesses should not be allowed to testify via video conference. The respondent's counsel, Lyndon, will be arguing that its witnesses should be allowed to testify via video conference, and that the claimant's witness should not be excused from giving testimony, and in the absence of this testimony, the witness's evidence should be ignored. So I will now hand it over to the tribunal to proceed with the mock hearing.
Thank you, Kate. Right, counsel, I think we can get started if there are no housekeeping issues. May I know if counsel for the claimant is ready?
Yes, I'm ready. Thank you, Mr. Chairman.
Yes, you may start.
Good evening, members of the tribunal, or good morning, depending on where you are today. My name is Alvin, and I represent the claimant Huckleberry Corporation in the proceedings today. If the tribunal does not require a recount of the facts, I will go straight into the two procedural issues that I will address today. May I know if that's okay with the tribunal?
Yes, please.
Thank you, Mr. Chairman. Members of the tribunal, we are here today to address two issues, procedural issues. The first one is whether the tribunal should excuse the claimant's witness, Mr. Americano's non-attendance at the hearing and admit his written statement into evidence. The second issue is whether the tribunal should not allow the respondent's two witnesses to testify via video conference. And we will submit that the two arguments on behalf of the claimant today is that first, the tribunal should excuse the claimant's witness, and second, that the tribunal should not permit the respondent's witnesses to testify via video conference. Now I start with my first argument. Here, we have two alternative arguments to make. The first is that Mr. Americano has provided valid reasons for his non-attendance at the hearing. In the alternative, there are exceptional circumstances here which justify admitting his written statement. I begin with my first point. We argue that Mr. Americano has valid reason to not attend the hearing, and the applicable rules here are the IBA rules on the taking of evidence in international arbitration. Now, Article 4.7 of the rules provide that the tribunal should only disregard a witness statement if a witness, and I quote, fails without a valid reason to appear at the evidential hearing. Now, the commentaries on the IBA rules tell us that it is uncontroversial that pressure from a witness's employer to not testify in a dispute constitutes valid reason for that witness's non-attendance at a hearing. And this makes eminent sense. A witness should not risk his relationship with his employer, in other words, his livelihood, in order to give evidence in a dispute, especially when that witness no longer has or does not have any personal interest in that dispute. Members of the tribunal, if I could take you to Mr. Americano's email to the claimant, dated 1st of June, 2020. You will see here that Mr. Americano's fear of jeopardizing his employment is very valid. If I could take you through that letter, it's at page 11 of the competition materials. If we look at paragraph 2 of that letter, here Mr. Americano says, "About a month after I signed my witness statement for you, I was terminated with immediate effect from my job at GEM without any notice or compensation. I'm sorry." Later in that paragraph, he says, "When my boss, Mr. Fastidio, handed the letter to me, he said, 'You've caused trouble for GEM with Narcissus. You know that Narcissus doesn't take this kind of thing lying down. And you really should have known better than to play the hero and stick your neck out for other people.'" Now from this paragraph, we can see that a person whose company has business dealings with the respondent should be concerned that testifying against the respondent would result in negative implications to his company and to his employment. And that is exactly Mr. Americano's worry here, as his new employer now also has business dealings with the respondent. And when one reads paragraph 4 of that letter, where he describes how losing his job once at GEM devastated him, his wife Peggy, and his family, it is hard to disagree that his fears that this might happen a second time are completely justified.
Counsel, can I please just ask, while we're on the subject, you made the point about the fear of losing his job if he acts against the respondent. But do we have any evidence that the respondent told his former employer to fire him? We know we have the evidence that his former employer potentially took that action because it was worried about its own relationship with the respondent. But is there any evidence that the respondent actually did anything to cause that?
Mr. Arbitrator, the only evidence that we have that the respondent did something like that would be Mr. Americano's letter itself.
And to be clear, his letter does not say that the respondent did anything. It says that his former employer did something, correct?
Well, I think that there is a pretty strong inference to be made from what Mr. Americano said that his employer said to him. You know, the words here that he used were specifically, you know that the respondent, Narcissus, doesn't take this kind of thing lying down. And that you should have known better than to stick your neck out for some other party. So we argue that from the words that were used in the letter, a strong inference can be made that the respondent exerts pressure on their business partners when it comes to employees testifying against them.
Thank you very much. Please continue.
Thank you, Mr. Arbitrator. Now, as I was just mentioning, the risk or the fear of losing one's livelihood is a valid reason for his non-attendance at an evidential hearing. And the ICC cases show that. In fact, the ICC cases show that far less exacting situations have been considered by tribunals to be valid reasons for a witness's non-attendance under Article 4.7. I refer the tribunal to the ICC partial award dated November 2012, and this will be found in my submissions. In that case, the tribunal decided that a witness who did not live in the same country as where the hearing was located had valid reason to not attend the hearing because he had limited means to meet the costs of attendance. Now, if a lack of financial means to attend the hearing constitutes valid reason under Article 4.7, then the risk of jeopardizing one's employment and their entire livelihood must also constitute valid reason for one's non-attendance. I now move to my alternative argument, which is that even if the tribunal disagrees with the claimant that Mr. Americano had a valid reason, Article 4.7 still allows the tribunal to admit the witness statement if there are exceptional circumstances which justify that. The thrust of our argument here is that Mr. Americano's testimony is so important to the claimant's entire case that it would be extreme to completely exclude his statement. We make 3 points to this end. The first is that his testimony goes directly towards the tribunal's assessment of the core factual issue in this arbitration. In the arbitration, the claimant's entire damages claim rests on his factual allegation that the respondent had pressured the resellers to choose geranium as their preferred distributor instead of the claimant. The respondent has denied this factual allegation, asserting that it allowed each reseller to freely choose their distributor. As such, the core factual issue in this arbitration is whether the resellers experienced this alleged pressure from the respondent. Now, Mr. Americano was the regional manager of GEM, one of the respondent's resellers. He was in charge of purchasing jewels on behalf of GEM from a distributor and directly involved in the process of appointing and switching distributors on behalf of his company. Therefore, he had first-hand experience of how difficult it was and whether such difficulty was caused or created by the respondent. Accordingly, his testimony provides the most direct evidence on this matter. Now, our second point is that Mr. Americano's testimony on the core factual issue is more direct and more probative than the respondent's witness's testimony on the same. The respondent's witness, Ms. Marvelous, is in the same company or was in the same company as Mr. Americano, but she was the CEO of the company. Now, although she claims to have been involved in GEM's process of appointing and switching distributors, she worked in a managerial capacity, unlike Mr. Americano, who was executing the process. As the CEO of the company, she would not have been as hands-on in the appointment process as Mr. Americano had, because she would have had to divide her attention to the other affairs of the company. Things such as sales or logistics, employment, all the things that other CEOs do. Now, the fact that she has now moved on to the CEO position of a company in a completely different industry shows that her experience and her expertise is focused on broader management and entrepreneurship rather than on the hands-on execution at GEM. As such, even if Mr. Americano reported to her, and even if she was ultimately responsible for calling decisions on distributors, she is unlikely to have the same direct knowledge of whether the switching process was difficult, as it was Mr. Americano who was actually executing it. So we argue that to wholly disregard Mr. Americano's evidence would greatly dim the light on the truth of this matter. Now, our third and final point is that even though Mr. Americano's witness statement will not be tested by cross-examination, the tribunal can still take that into account when assessing the credibility, the weight, and the value of Mr. Americano's statement, instead of completely disregarding it.
Also, that's really the point, isn't it? You say that Mr. Americano's testimony is central to this whole issue, and his witness statement makes allegations about what the respondent had told him or told his company. but then he's not to be cross-examined on that. How is the respondent going to challenge or test the veracity of his testimony without cross-examination?
Mr. Chairman, I agree that it is unfortunate and it is a shame that such an important piece of testimony cannot be tested by cross-examination. But in the circumstances, and as Mr. Americano has explained the circumstances, I think that there is no other option to help the tribunal understand what really happened at the time. No better choice than to accept Mr. Americano's statement into evidence, but take into account, perhaps give it less weight if the tribunal so determines. And in addition to that, the good thing here is that not only Mr. Americano is giving testimony on this issue and on this specific factual issue, the respondent's witness, Ms. Marvelous, will also be giving her statement, and her statement can be tested by cross-examination. So, you know, if two people are saying two completely different things, then if Ms. Marvelous can be tested at cross-examination, how she performs will lead to the tribunal's inference as to how truthful or how accurate Mr. Americano's testimony is. So in that sense, we say that there is still some basis for the tribunal to determine the weight of Mr. Americano's testimony without having him physically on the stand.
I know you have to move on to the, sorry, Julie, do you want to jump in here?
By all means, you should finish your questions. I was going to jump in with another one. I can do that after you complete your question.
This is related to what counsel submitted, so sorry. And you don't have to give me a long answer, but your answer that the respondent's witness can be cross-examined doesn't really answer the point that the respondent has no chance to cross-examine your witness, because you will be cross-examining the respondent's witness. So that's not really a benefit to them. It's a double prejudice to them, isn't it? And you have also said that Ms. Marvelous' testimony is not that important because she didn't know the hands-on operations.
Yes, Mr. Arbitrator. My short answer to your question would be that even though the respondent will not have the chance to cross-examine Mr. Americano, and that is unfortunate, but in the circumstances, we say that to completely disregard his statement is an extreme position to take, but the tribunal could accept it into evidence and give it less weight if it deems that, oh, this testimony has not been cross-examined, has not been tested by cross-examination, and so we give it perhaps to take it with a pinch of salt, for example, but at least the statement is still admissible and will still be considered by the tribunal.
All right, Ms. Badard, sorry to interrupt you.
Not at all. So I have a related question, and it is this: whether there's any middle ground here. Would you consider the possibility of permitting the cross-examination by video conference, for example, instead of physical attendance? And the other, I really have two questions, and they're related. The other is, what is really the harm at this juncture if we already have the consequences that you described to us? What further is going to happen if the witness is cross-examined?
Thank you, Madam Arbitrator. To answer your first question, unfortunately, Mr. Americano will not be able to do to testify via video conference, because his concern here is that to even be involved in the proceedings, to testify against Narcissus, would lead to his current employer terminating him, or result in some sort of negative implication to his employment. So for him, that fear is valid whether he does the testifying in person or by video conference. to answer your second question, Madam Arbitrator, sorry, Madam Arbitrator, could you just briefly repeat that second question for me?
I think you already answered it just now and stating that you believe there would be further consequences in facing a potential loss of employment. So the way you see it, you're looking to avoid harm. You're not looking at a situation the harm has already been caused.
That's right. Harm had already been caused, and that is evidence that shows that further harm is going to be caused if Mr. Americano now chooses to testify again. So thank you, Madam Arbitrator and Mr. Chairman, for your questions. I will move on to my second argument on the second issue today, and that is that this tribunal should not allow the respondent's two witnesses to testify via video conference because they have not shown good cause. Now, unlike Mr. Americano, who had a valid reason for not attending the hearing, the respondent's two witnesses, on the contrary, have not shown good cause for their request to testify via video conference. Now, the standard here is provided under the 2014 IBA commentaries on the IBA rules. While Article 8.1 of the IBA rules allow the tribunal to use video conference technology with respect to a witness testimony, the IBA commentary states that when a witness applies to appear by video conference, that witness should state sufficient reasons why he is unable to appear in person and propose a protocol to maintain equality and fairness among the parties and approximate live testimony. We argue that both of these requirements are not met, but I will focus on how the respondent's witnesses have provided insufficient reasons for their non-attendance in person, because there is no need for parties to spend time discussing the protocol if the tribunal agrees with us on that point. I start with Ms. Marvelous's reasons for not appearing in person. Now, Ms. Marvelous says that she is unable to appear in person because she is expected to receive government approvals for her present company's movie project on the same week as the arbitration hearing. However, she has not explained exactly why she needs to be physically in Dubai to receive the government's approval. Typically, an administrative task such as receiving an approval would not be for the CEO, but would be delegated to lower level employees of the company. Apart from vague assertions, Ms. Marvelous or the respondent have not given enough detail to her explanations to constitute sufficient reason. And this is a burden that they both have to discharge. Now I turn to Mr. Diamond, who is the CEO of Diamond Industries, another reseller who had to pick a distributor. Now his reason for being unable to appear in person is similarly insufficient. He says that his knowledge is indispensable for his company's urgent R&D of virus-proof masks in London, but he has not explained the basis of his alleged knowledge in such types of R&D. For example, whether he has a general bioengineering background. All we know is that he was previously the founder and CEO of Diamond Industries, a reseller of the respondent's jewel products. The respondent has not shown how Mr. Diamond has now become an expert in bioengineering R&D. And even assuming he has such knowledge, the respondent has not shown why he needs to be physically in London to impart his knowledge to his employees. And for these reasons, members of the tribunal, we argue that Ms. Marvelous and Mr. Diamond have not provided sufficient reasons to justify giving evidence by video conference. If I may sum up my arguments for the tribunal today, I have 3 minutes left. On the first issue, we argue that under the, yes, Mr. Chairman, I think you're on mute.
Yeah, just summing up. So maybe I can take the time to ask you a question about this. What is the harm really in video testimony? If it's a matter of balancing, what is the harm?
The harm here is that, well, the biggest harm, in our opinion, is the the lower effectiveness of cross-examining these witnesses over video conference. And in addition to that, it's not just about the harm of video conference itself. It is that the rules which the parties have both agreed to, that is the IBA rules, provide that these witnesses have to provide sufficient reasons for their non-attendance. Their reasons are unconvincing and they don't seem to make a lot of sense. And that gives the impression that these witnesses are trying to avoid cross-examination in some way. And so that is really the concern here. It's unlike the situation of Mr. Americano, who has already been terminated by his employer once, and that is why he is unable to appear. Thank you, Mr. Chairman. I'm not sure if I have time left.
You might have 1-2 minutes if you want to use it.
Yes, okay, in that case, I will just quickly sum up my two arguments. Now, the first one is that under the Article 4.7 of the IBA rules, even where a witness does not appear for the hearing, the tribunal may still admit his statement in two possible instances, either where the witness has a valid reason for not attending, or where there are exceptional circumstances which justify admitting his statement. We submit that both grounds are satisfied, and if the tribunal agrees with us on any one of those two grounds, then Mr. Americano's statement must be admitted. And our second argument has been that the tribunal should not allow the respondent's two witnesses to testify via video conference because they have not shown sufficient reasons why they need to do so. Thank you, members of the tribunal, and I hand the time over to Mr. Linden, the counsel for the respondent.
Thank you. Yes, is counsel for the respondent ready?
Yes, Mr. Chairman. Mr. Chairman, members of the tribunal, good evening. My name is Linden Chu, and I'm counsel for the respondent in the present proceedings, Narcissus International. I will address this tribunal for 25 minutes on the two primary issues before this tribunal. The first, on why the claimant's witnesses' statements should not be admitted as evidence given the witness's unwillingness to testify before this tribunal. And second, why the respondent's two witnesses ought to be allowed to testify via video conference. I reserve 5 minutes for my reply. Before addressing these two primary issues proper, I would just like to provide this tribunal with some procedural background to the present proceedings. The present proceedings were initiated on the 24th of September 2019, and the first hearing was meant to be fixed on the 13th of April 2020. However, due to the times that we find ourselves in, as well as the COVID-19 situation, that hearing was postponed to the 10th, between the 12th and the 16th of October 2020. However, yet with the ongoing travel restrictions, that hearing has simply not taken place. It's with these circumstances in mind that we now turn to address the first primary issue. We say that the claimant's witnesses' statements should not be admitted into evidence for three reasons. First, parties have placed a significant premium on the ability to examine the witnesses at a hearing. Second, the claimant has failed to adduce valid reasons or exceptional circumstances to justify such an exception. And the third is that the respondent will be significantly prejudiced by its failure to examine Mr. Americano on the stand. Turning now to our first reason. While my learned friend Mr. Tan has sought to downplay the significance of the claimant's request to admit Mr. Americano's statements without examination, this tribunal should be slow in granting such relief. Parties have agreed for the SIC rules as well as the IBA rules to apply to the present proceedings, and under both sets of procedural rules, the default position is for witnesses to be available for examination at a hearing. Order 9.3 of the pre-hearing procedural order, which may be found on page 14 of the agreed statement of facts, simply provides that the default position is that the failure of a witness to be made available for examination will result in the exclusion of that witness's state evidence. And the premium that parties have placed on the examination of witnesses cannot be underestimated, as parties have agreed to an adjournment of the hearing previously simply because the hearing couldn't take place and the examination of witnesses could not take place. Now, if parties place little weight on examination of witnesses, this hearing could simply have been resolved back in April, but parties chose not to. Turning to the second reason, we say that Mr. Americano's absence from the hearing is not supported by good cause or justified by exceptional circumstances for 2 points. First, the reasons and evidence put forth by the claimant thus far are wholly inadequate to constitute good cause or valid reasons. My learned friend has earlier stated, and I quote, Mr. Americano has already been dismissed by his previous employer for testifying against the respondent. And he has made this similar point in his written submissions as well. But members of the tribunal, with respect, this is a misrepresentation of the facts. If I may trouble this tribunal to turn with me to Mr. Americano's letter at page 11 of the Statement of Agreed Facts. In Mr. Americano's letter itself, he concedes and has not ruled out that there are other reasons for his termination from GEM, such as differences with his supervisor. And I quote from his letter itself, he says, I don't know if what Mr. Fastidio said to me was true, or if he was just finding excuses. We have had our differences too. As Mr. Tassino has observed earlier, there is no evidence that the claimant speaks of within this letter that points towards the respondent having any role in the termination of Mr. Americano's employment at GM. And we say that what the claimant can point to is at best mere inferences as I suggested, which is insufficient for the present purposes. In fact, the respondent has already gone on record to state that it has nothing to do with Mr. Americano's termination, as can be seen in the respondent's response to tribunal at page 11 of the Statement of Agreed Facts. So in the absence of any such evidence, we say that it's premature and incorrect for the claimant to suggest that the respondent has been in any way complicit in Mr. Americano's termination from GEM.
Can I ask, counsel, excuse me, sorry to interrupt you, but just one question. In your view, would we need to find that the respondent was complicit in this in order to excuse his absence? Or is it enough if he himself has a genuine concern that his new employer would terminate his employment?
Mr. Tassino, that's a very good question. In our view, we say that it's insufficient for Mr. Americano to merely hold that perception in his mind. And we say so because under the present jurisprudence concerning this article in the IBA rules, it's not sufficient for a witness to suggest that he is not willing to participate in a hearing. It must be that he is unable to attend the hearing. And the difference is significant because in instances of situations where witnesses have been allowed not to participate in a hearing, this has been due to reasons such as visa requirements, physical incapacity, or situations such as severe lack of means. And these are all reasons which are out of the claimant's, the witness's control. And we say that that must be the standard that this tribunal hold the exception to. Because to allow the exception to be used at a lower threshold would then give rise to risk of possible abuse of this section, such as in instances where the witness is able to attend the hearing but merely chooses not to attend for tactical reasons, and may just give trumped up reasons such as fear of certain retributive actions from the opposing party. On the facts, Mr. Americano has not suggested that he is facing pressure from his current employer for his involvement in the current proceedings. In fact, Mr. Americano simply cannot prove any facts, as I earlier stated, to suggest that GM had terminated him specifically because he was involved in the present arbitral proceedings. Mr. Americano himself acknowledges in his letter that he has chosen not to take part in the present proceedings for his own reasons, such as pressure from his wife. My learned friend has also stated in response to Ms. Badard's question that Mr. Americano cannot even testify via video link because he fears being terminated. However, it's hard to see how Mr. Americano can avoid offending the respondent if his statements are in fact admitted into evidence by this tribunal. His statements and his evidence would still form part of these proceedings, and Mr. Americano's fears are in reality nothing but a facade of his own imagination. And in light of this, we say that there's clearly nothing stopping Mr. Americano from participating in the present proceedings, except for his own unwillingness and unfounded fears, which we say are not sufficient reasons for this tribunal to excuse him from attendance at the hearing. We also like to point out to this tribunal certain issues regarding the claimant's reliance on the case of the ICC partial award dated November 2012. In our submissions, my learned friend's reliance on this case is misplaced. And we say so because this authority stands for the proposition that a witness who is unable to attend a hearing for his lack of means may be exempted from attending the hearing. And that's pretty far divorced from the present facts. The witness in that case in particular did not even have the means to arrange to give evidence via video conference. Another reason as to why these present proceedings differ from this authority stated by my learned friend lies on the fact that one of the factors that the tribunal in that case considered was, and I quote, "Witness statement does not go much, if at all, beyond confirming the contents of the respondent's statement." In other words, the witness in that case was not a significant witness, quite unlike Mr. Americano, whom my learned friend describes as a very important witness to the present proceedings. As Mr. Chairman has earlier observed, if Mr. Americano is such an important witness, his statements should be tested for veracity on cross-examination. Otherwise, the respondent will be seriously prejudiced. And this brings me to my third reason under the first as to why Mr. Americano should not be excused from attendance at the hearing. We say so because the respondent will be significantly prejudiced if he is unable to examine Mr. Americano on the stand. As various academics have stated previously, as well as stated in various judicial pronouncements, the cross-examination is perhaps the greatest legal engine ever invented for the discovery of truth. By allowing Mr. Americano's statements to be admitted without examination would give the claimant an unfair advantage over the respondent, as noted by Mr. Chairman earlier. And this is a potential ground for a challenge to be made against this tribunal's eventual award.
Well,
but the respondent,
I don't think we are worried about that challenge. So you can keep that in reserve.
Certainly, Mr. Chairman, we're not saying that the respondent is intending to take such a challenge. We're saying this is a possibility and in fact was done in various other cases. Of course, whether it will apply the present facts would depend very much on what comes out of this entire hearing.
The point that you raised about the importance of Mr. Americano's evidence or testimony, it cuts both ways, right? And maybe you can advise a tribunal on how to do the balancing exercise, because if we deprive the claimant of his testimony altogether, then they don't have testimony on that important issue. Whereas if we allow it, then the only prejudice to the respondent is that you can't do cross-examination. Are there not other ways that you can employ to challenge that testimony?
Certainly, Mr. Chairman, we say that our primary position is that since this is the claimant's witness, the claimant bears the consequences of the witness's absence from the hearing. So if the witness chooses not to attend the hearing and there are no exceptional grounds, then it is for the claimant to bear the responsibilities of its decision in fueling this witness in the first place. But as to what alternatives can be put in place, we say that one possibility might be what Ms. Badard has earlier suggested, for video, for Mr. Americano to give evidence via video conference. And we say that this would in fact be a suitable solution in the present proceedings, given that there are various travel restrictions in place, a point which I will address in my arguments for the second submission. Yeah,
No, please carry on.
thank you, Mr. Chairman. We say that by allowing Mr. Chairman, just one more point on the earlier point, which is that while it's true that the importance of a witness's statements cuts both ways, at this preliminary stage of proceedings, given that this is mainly a hearing on procedural issues, this tribunal need not place that much weight into the substance of the statements given by various witnesses, and it ought to look more at the procedural aspects as well as the reasons given for any deviations from procedural norms. For the reasons stated earlier, we submit that there are no valid reasons for excusing Mr. Americano's attendance at the hearing. Turning to the second issue, we submit that the respondent's witnesses should be allowed to give evidence via video conferencing, since they will have provided valid reasons for the inability to attend the hearing in person. And the respondent would not be prejudiced, apologies, the claimant would not be prejudiced by the respondent's use of video conferencing. Turning to our first reason to support our submissions, we say that sufficient reasons have been given for why the respondent witnesses are unavailable to be present at the hearing, since these witnesses have professional commitments to attend to, and Singapore's travel restrictions currently make it impossible for the witnesses to attend the hearing in person. Previous tribunals have typically considered valid reasons for allowing witnesses to attend hearings remotely to include professional inconvenience. And a key consideration that previous tribunals have taken into consideration is whether the reason for the witness's absence was foreseeable at the time when the hearing was fixed. And this was stated by the treaty in the treatise, the Guide to IBA Rules. Here, the respondents' two witnesses have already stated their professional commitments require them to remain in Dubai and London respectively. And these commitments were only known after the hearing was fixed and the statements were submitted in March, as can be seen from page 9 of the Statement of Agreed Facts. While the claimant has sought to question the reasons given by the respondent's witnesses on the adequacy of the reasons given by the respondent's witnesses, we say that the claimant has mainly adduced no credible evidence to justify why this tribunal should disbelieve the reasons given. The claimant is, in other words, merely grasping at straws to find fault with the respondent's witnesses, which we say is inappropriate. Moreover, the claimant's attacks on the sufficiency of reasons given by the witnesses for the inability to travel to Singapore fails to take into account the various travel restrictions that are currently in force in Singapore due to the COVID-19 situation. To date, the travel restrictions continue to apply for short-term visitors coming in from Dubai and London, and it's impractical as well as infeasible for this tribunal or the claimant to insist that witnesses attend the hearing in person when they simply cannot. As this tribunal may recall, one of the grounds in which tribunals would allow for video conferencing is where there are visa issues. And we say that this is one such situation where the tribunal should exercise its discretion to allow the witnesses to testify via video conference. Turning to our second reason in support of our submission, we say that the respondent is not prejudiced because suitable protocols can be put in place to ensure that remote hearing approximates an in-person hearing at a lower cost. And this notion of an approximation of an in-person hearing is a submission which I'm sure my learned friend would agree with, as he has similarly stated that that is the standard to be achieved in the use of virtual hearings. We should clarify, at this point, we should clarify one point which has surfaced in my learned friend's written submissions, and that's the notion that the respondent has failed to adhere to the need to adduce some sort of protocol for the use of video conferencing. We should clarify that the respondent has not adduced such a protocol at the time of filing the application, because there was no agreement reached on this matter at the time by parties, although we have always been prepared and are ready to engage the claimant on the appropriate protocol to apply. As can be seen from page 9 of the agreed statement of facts, the respondent has previously sought the claimant's agreement on the use of video conferencing for its witnesses to testify at this hearing. However, the claimant has objected to our request without giving any reasons, suggesting that its objection was really more fundamentally with the use of video conferencing as a tool. And this outright objection was similarly repeated in the claimant's letter to the tribunal dated 19th of June 2020 at page 10 of the statement of agreed facts. We say that in our present submissions, the exclusion of the protocol from the application is not fatal, because as the commentary to the IBA rules provide, there are various factors that this tribunal balances in determining whether to allow an application for video conferencing. And one of the factors that this tribunal considers includes the cost savings that may be achieved through the use of video conferencing and the sufficiency of reasons given by the witness. On the facts, we say that the facts suggest and tilts in favor of this tribunal exercising its discretion to grant our application for the witnesses to testify via video conference. As earlier stated, there are sufficient reasons, including but not limited to the travel restrictions, to justify the use of video conferencing. Further, we also say that the use of video conferencing would achieve cost savings, given the fact that parties can now save on expenses such as airfares, as well as hotel accommodations. But more importantly, we say that given the fact that the present proceedings have already been postponed once, to deny the respondent the use of video conferencing would simply lead to lengthy and indefinite delays to the proceedings, which are not beneficial, and it goes against this tribunal's objective in ensuring a fair, cost-efficient, and cost-effective resolution of the parties' disputes.
But counsel, the tribunal is not minded to postpone, of course, the hearing. Don't you agree that the IBA rules having been incorporated into this arbitration by agreement, the default rule is that the witnesses need to be before the tribunal, need to appear. And if your clients want them to give testimony by remotely, then the burden is on them. And the argument by the claimant is that the reasons given were very vague. Why would Ms. Marvelous need to be there to receive government approval? And why does Mr. Diamond need to be there for R&D? Right? So the burden is on you, and are those sufficient reasons where they don't really explain why they need to be there?
Well, Mr. President, we have instructions from the respondent that the witnesses are happy to supplement the reasons given in their letter as to why to satisfy this tribunal on the deficiencies in reasons which my learned friend has earlier stated. But we say that in addition and apart from these reasons stated in the letter, this tribunal should simply not lose sight of the present circumstances that parties find themselves in, including the travel restrictions that are in place. And we say that even if the respondents' witnesses are willing and able to come to Singapore for the hearing in October, there's simply no way that they can do it, given the fact that the travel restrictions are still in place. And we say that the reasons, the work commitments are about one part of the reason, and there's still sufficient reasons provided by the respondent to justify this application, even if this tribunal does not find in favor of us in respect of the work commitments. Finally, before I conclude my presentation, while my learned friend has addressed these issues relating to remote hearings at length in his written submissions, but I noticed that I note that he has not had the opportunity to address them, given that this issue is one which closely relates to the absence, the claim that we have failed to use a protocol in our submissions. We think that this is necessary. It is necessary for us to address this tribunal. My learned friend has raised various issues, including the fact that there is possibility of hidden assistance to witnesses or inability to observe the witnesses' body language. But respect members of the tribunal, we say that these problems are easily resolved with the right use of the appropriate cameras, appropriate camera setup, or the appropriate protocol to be agreed between parties. And the only reason as to why this protocol is not before this tribunal today is because of the claimant's reluctance to reach any sort of agreement or engage in discussions with the respondent on this issue. In conclusion, we implore this tribunal to consider parties' interest in having a fair, expedient, and cost-effective resolution of their disputes and find in favor of the respondent on both preliminary issues. Unless I may have any further assistance to the tribunal, this concludes the respondent's submissions.
Do my co-arbitrators have any question for counsel?
I do. With respect to Mr. Diamond, so he's working in, is he working in the lab on the vaccine, or is he working remotely from home? And the reason why I'm asking is, if he's working remotely, presumably he could attend the hearing and continue to work remotely on the vaccine. So do you have any information about that?
Unfortunately, Ms. Badard, we don't have information on that, but we do know that we understand that his company is in urgent R&D, which probably suggests that they require all hands on deck, and therefore he's unable to leave his post of work. But of course, we are, Mr. Diamond has already stated that he's more than happy to attend this hearing via remote means, and that's a position which we maintain in the present proceedings.
Thank you.
Thank you. Unless I may be of any further assistance, this concludes my submissions. Thank you.
Thank you, Mr. Chu. Mr. Tan, do you have a rebuttal or reply?
Yes, Mr. Chairman, I would like to make 3 points in rebuttal to the respondent's submissions. The first one is that we reject the respondent's allegation that we have misrepresented the facts with regard to Mr. Americano's circumstances. We would like to make clear to the tribunal that we did not say that the respondent definitely did pressure Mr. Americano's employer. We said that it was a possibility based on reasonable inferences from Mr. Americano's letter. Now, we argue that there is no need to show that the respondent did in fact pressure Americano's employer. It is enough that Mr. Americano is genuinely afraid of sticking his neck out to testify, given that it is a possibility. Now, we argue that a risk that this might happen is enough to justify his non-attendance because the consequences are gravely serious, especially in these times where people are losing their jobs and not able to find new ones. My second point is in response to the respondent's attempt to distinguish the ICC case that we have cited in our submissions. Now, in the ICC case, it is true that the facts involved a witness who had no financial means to show up at the hearing. And here, Mr. Americano is sacrificing his livelihood to give evidence. The facts are not exactly the same, but the underlying concern is. And that is that a witness should not sacrifice his own financial interests to give evidence in a dispute. Now, the respondent also sought to distinguish that case on the basis that Mr. Americano is an important witness and the witness in that case was not. But we argue that especially because Mr. Americano is such an important witness, his statement should not be excluded entirely, and that the tribunal should accept it, but give it its appropriate weight. Now, on our third point of rebuttal, we maintain that the respondent's two witnesses have not provided sufficient reasons for using video conference. Their reasons given are shaky in logic, and it is unconvincing why they need to use video conference to give evidence. It is very unfortunate, but we cannot compromise fair and proper proceedings for the sake of rushing to conclude the arbitration. If it has to be postponed, then it should be. Here, the parties have agreed that the IBA rules apply, and Article 4.7 says, my mistake, members of the tribunal. This should be Article, sorry, my mistake. This is the commentaries to the IBA rules. It says that a witness who wishes to apply to give testimony by video conference has to provide sufficient reasons, and here the respondent's two witnesses have not. With that, I sum up my rebuttal submissions. If the tribunals have any questions, I'll be happy to answer them.
Can I just ask you one quick question, counsel? On your second point, you talked about the fact that we can determine what weight to give the witness statement. Do you have any guidance to offer on how we would decide what weight to give it? What would we base that decision on if he does not testify in person?
Thank you, Mr. Arbitrator. I think the practice in international commercial arbitration, as shown in the commentaries and the cases, is that the tribunal can give it just generally less weight if that testimony is not tested at cross-examination. But in addition to that, we argue that in the circumstances of this case, especially when you have another witness from the respondent who is testifying on the same issue, who was from the same company as Mr. Americano, but was his superior, we can judge how truthful or how accurate Mr. Americano's statement is by reference to how well Ms. Marvelous performs at cross-examination. If Ms. Marvelous does not seem to know what she's talking about, then it would prove that Mr. Americano's statement has greater weight and is more credible, or vice versa. And if the tribunal has no further questions, I end my submissions here. Thank you.
Thank you. Mr. Chu, do you have a third rebuttal?
Yes, I do. Members of the tribunal, 3 points in reply. The first is that we say that it's insufficient for Mr. Americano to use his trumped up fears as an excuse to avoid testifying at this hearing. As Mr. Tassino has earlier noted, there is no evidence of any causative link between the respondent and Mr. Americano's termination at GEM, and we say that such a causative connection is necessary, as can be seen in the decision of Karatube and Kazakhstan and ISID tribunal decision. We also say that the claimant has overstated the detriment that is suffered by Mr. Americano by his termination from GEM, as well as by his involvement in present proceedings. We note that Mr. Americano had the means to relocate with his entire family after he was terminated. And we say that this is clearly not the actions of someone with limited means. On the second point of rebuttal raised by my learned friend, we say that there's the facts of the decision, the precedence is simply completely divorced from the present facts and should be disregarded. On the third point, we say that my learned friend has still not addressed the reasons proffered by respondent on why travel restrictions would not constitute a sufficient reason to justify this tribunal allowing the two witnesses to testify via video conference. And we say that in light of these reasons, the claimant's points must fail. Unless I may be of any further assistance to this tribunal.
Yeah, I think the answer to that, and the reason why he didn't address it, is that the COVID-19 is fake news, right? It's a hoax.
Well, Mr. Chairman, I
have it from the highest authority in the US currently.
Currently, because we all know that in January some changes will occur on that front.
No, that is also fake news. Okay.
Yes.
Thank you anyway.
Thank you.
Do Ms. Badard and Mr. Tassano, you have any further questions?
Nothing further on my end, but thanks for the humor.
I do not either, and as an American sitting here, I can't enjoy the humor quite so much, but no other questions.
All right. Well, I think that brings us to the end of the submissions, and the tribunal will be giving comments. We will reserve our decision because we haven't consulted, and we do not have a breakout room to consult and give you a decision. So we will, I think, move directly to comments and tips. Julie, would you like to start?
Yes, thank you. I appreciate that. So I think on my end, I was quite impressed by both presentation. On the side of claimants, you were poised, you were very clear. And I think for both of you, there was a great sort of courtesy, lack of aggressiveness that we see perhaps too often, that really does nothing to advance the party's position. And I've been told many times before by arbitrators in cases in which I appear as counsel that the arbitrators prefer to focus on the substance than on the way the presentations are delivered. And I think in that respect, both counsel really score some points. I do think that you had some limitations based on some of the facts that were given to you, and not you both had a bit of an uphill battle in some respects in each of the requests that were made. And you might, for counsel and the respondents, you might, when the facts don't give you all the ammunition you need, and this is true in real life also, right? You sort of really have to do what you can, but I think you might have considered giving us additional facts, perhaps on the reasons why these people were not present, but it's or could not be present in person. I thought that the facts were extremely limited in that regard, and maybe that's part of the factual problem, and was maybe your biggest challenge in trying to discharge the burden to the tribunal without really any concrete evidence of why these people couldn't show up at the end of the day. But I commend both of you for the presentations you have given, which in many respects were exemplary in their clarity. Because I thought you strike a nice balance between, you obviously had a presentation in front of you, and I apologize for the background noise. This is the new world in which we live. But you were able to, you weren't, yes, you were looking at your notes, but this was very much a live presentation. At no point were we bothered by the fact that you were looking at your notes, and having your notes allowed you to have a very organized and structured presentation. So I thought you struck a nice balance there.
Thank you very much, Ms. Badard, for your very helpful comments.
Jack?
Yeah, I agree with those comments. I think you both did a very good job on the presentations. A couple of things that struck me in particular was, for instance, both of you for a moment seemed to lose your place in your notes, and you had a bit of silence. One of the strange things about this, again, the new world we're in, was I think everyone for a moment thought, wait, did the screen freeze? or, are they just pausing? But it was just a pause while you sort of collected yourself. But I think you both did a good job of not seeming at all flustered in that. A lot of times people are afraid of the silence and they feel like they have to just always keep talking. And it's perfectly fine to take a pause, find your place again before you move on. And I thought you actually both did a very good job of doing that without seeming to get flustered at all. The other thing I think you both did a very good job of was responding to the questions. We all asked some questions, a couple of them kind of tough. As Julie mentioned, some of them didn't really have the support in the factual record that you had before you to give a good answer for it. But I think you both did very good job fielding those questions. If anything, the only advice I would give is on the rebuttals. We always talk about the fact that you're very unlikely to win your argument on a rebuttal, but you can lose it if you're not careful. And so you always want to be very limited in what you say on rebuttals. I think both of you, your rebuttal was fine, but it did seem, at least to me, a little bit too prepared. So not necessarily just directly responding to something that had actually just been said, but more making points that, in some cases, points that you had already made, you sort of repeated on rebuttal. So I would just keep an eye on that and try to make sure that you try to keep your rebuttals very focused and really hone in on something that the other side actually said that you think you can, you need to respond to on the rebuttals. But otherwise, I think you both did a very good job with it.
Right. Totally agree with what Julie and Jack have said. Well done, both of you. Their observations on the limitations that you have are well acknowledged, and you have done a very good job. I'd just like to share a little bit as well. Obviously, both of you have winning entries, and what we, the judges, felt were good in the winning submissions. There are others which are very good as well. So they have some common traits, and that is they're well structured. They argue very clearly, and they are easy to follow in terms of both your legal authorities as well as the logic of your arguments. One thing about questions like that of procedure that come up in arbitration, very often you'll find that it's not so much a decision that will be made on hard law, because in arbitration there's a lot of flexibility. And as both of you have I think, recognized in your submissions, yes, you start with some general principles like the IBA rules or maybe SIAC rules, but eventually from there, it will be a lot about what the tribunal should decide on the facts within the discretion that the tribunal has. And one thing that you have both done well was to utilize the facts as limited as they are to the best that you can. Right, so that's usually what you need to do in advocacy. That usually is quite fact dependent, and you are just trying to persuade the tribunal why on these facts it should be decided this way. With regard to the oral advocacy, I again endorse what my colleagues have said. The questions and answer sessions were handled quite well. One thing that the respondent did particularly well was to adapt his presentation to what the claimant had said, right? So even when Lyndon, you were presenting, you were already adapting to what the claimant has said. And that's what you really need to do. By the time you get to the oral hearing, you should actually have read all the submissions on both sides. And maybe you would have thought about how you want to approach your oral a little differently. And Lyndon's answers were, I thought, particularly creative, because I like the way you answered difficult questions. And then when the arbitrator was silent, giving you more time and more opportunity, then you took that opportunity to actually reinforce the point based on what you have already prepared elsewhere, right? So I think the bottom line is, in oral submissions, you really need to think on your feet and be very alive to what the tribunal is thinking, even though it's on Zoom, right? And you just need to react to the situation and adapt. So I think you've both done a pretty good job.
Yeah. I apologize for interrupting. It looks like I may need to drop to deal with a bit of an urgent matter here. So I may let my co-arbitrators complete the comments session, and I apologize greatly for the inconvenience, but this seems to be quite urgent and significant. So with apologies and congratulations again to the counsel here involved. You hold great promise, and we hope to see you in real cases. Many thanks.
Thank you, Julie, and good luck. Well, I've actually come to the end of my commentaries, and should I leave it back to Jack if he's got any follow-up, or to the organizers who have done a very good job with this as well?
If you have any comments, I think we can conclude the session as well.
Sure.
So just what's left for me, I think, is just to say congratulations again to Alvin and Lyndon. Well done. And a special thanks to the panel of judges. Thank you for joining us today and for judging the briefs as well. And also a thanks to Freshfields as the prize sponsor, and to our supporting organizations, and to the Young YSIAC Publication Subcommittee, and to YSIAC as well, especially Sokwi, Siouan, Dina, and Lynn for organizing this event. And I think have a good rest of your day.
Thank you, Kate. Thanks.
Thank you.
Thanks, everyone, and congratulations again, guys.
Thank you very much, everyone.
Bye-bye.
Thank you.